Imagine, you're an employer, you're hiring for this really senior role, you run a standard background check, and boom, a federal drug possession charge pops up.
Right, which usually sends people into an absolute panic.
Exactly. So you do what feels like common sense. You rip up the candidate's job offer to protect your company.
hmm
But in Canadian human rights law, you didn't just protect your business.
No, you actually just handed that applicant the exact ammunition they need to sue you for medical discrimination. And honestly, you will probably lose.
Which is wild to think about. And it brings us to the mission for our deep dive today. We are pulling apart a stack of research centered around this brilliant legal breakdown by Tony Wong from HTW Law.
It's a great article.
It really is. He details this hyper-technical collision between constitutional frameworks, rigid workplace statutes, and just the messy reality of hiring and firing in Canada.
Yeah, and what's fascinating here is that when people enter the workplace, they carry this abstract concept of fairness with them. They just assume that if they act reasonably, the law will back them up.
Like relying on a general moral compass.
Exactly. But human rights law in Canada is not a moral compass. I mean, it is a highly engineered, deeply strategic machine. If you use the wrong tool or make the wrong assumption, the machine crushes you.
So whether you're an applicant trying to navigate a background check or a company trying to manage a team, relying on your gut feeling is a guaranteed liability. Today, we're tracing how one misplaced assumption can destroy a career or cost a company a massive settlement.
And to understand how these claims actually operate in practice, we really have to start at the foundational level. Before we even look at discrimination or background checks, we have to figure out which rule book even applies to you.
Right. I look at it like writing code for a smartphone. If you take iOS code and try to run it on an Android phone, the app crashes immediately. The code itself might be beautifully written, but because you are in an entirely wrong operating system, it just fails.
That's a perfect analogy. In Canadian law, if you bring a perfectly valid human rights claim to the wrong jurisdiction, your case crashes before a judge even looks at the facts.
So where does that operating system divide actually come from?
It stems from the constitutional architecture of Canada, specifically the Constitution Act of 1867. It dictates this strict division of powers between the federal government and the provinces.
Okay, so let's talk about the federal sphere first.
So the federal sphere is governed by the Canadian Human Rights Act. But, and this trips a lot of people up,
Yeah.
it doesn't apply based on where a business is physically located. It applies based on the pith and substance of the operation.
Pith and substance. I mean, that is a phrase only a lawyer could love. Break down what that actually means for the listener.
Right, sorry. It basically looks at the inherent core nature of the industry. So, are you working in banking, airlines, interprovincial telecommunications?
Maritime shipping, things like that.
Exactly. If your industry crosses national or provincial borders by its very nature, you're federally regulated. It also governs Indigenous band councils. The sources highlight this specific case, Simon D. Thessalon First Nation, which is a great example.
What happened there?
Well, an applicant tried to take a band council to the Provincial Human Rights Tribunal. And the provincial adjudicators didn't even look at the evidence. They just pointed to the door and said, we have zero legal authority over inherently federal matters.
Wow. So if you aren't an airline pilot, a bank teller, or working on a Federal Reserve, you fall into the other operating system.
Yeah, the vast majority of the time. About 90% of the Ontario workforce is provincially regulated. So retail, hospitality, tech startups, construction, healthcare, all of that falls under the Provincial Human Rights Code.
And all those complaints go to the Human Rights Tribunal of Ontario.
Yes, exactly.
But this is where we need to introduce a major reality check, because people hear the words Human Rights Tribunal and they imagine like a generalized workplace fairness board. They think, my boss is toxic, I'm being bullied, I'm going to the tribunal.
Oh, people think that all the time. But the Ontario Superior Court completely shut that idea down in a case called Havey, Ontario.
And what did the ruling say?
It clarified that a toxic boss who yells at everyone equally is not committing a human rights violation. To even get in the door, you must prove a direct, undeniable link between the adverse treatment you suffered and an enumerated ground protected by the code.
Meaning things like age, race, gender, or disability. But, knowing the difference between federal and provincial jurisdiction is only half the battle. How do employers even find out about your past to discriminate against you in the first place?
Well, that usually comes down to background checks.
Right. Which brings us to one of the most volatile enumerated grounds, the record of offenses or criminal records, because the rules here seem completely counterintuitive.
They really do.
Let me push back on this for a second. Under Ontario's police record check laws, it is actually a criminal offense for an employer to request a vulnerable sector check for a standard desk job. Shouldn't a business owner have the absolute right to know the full history of the person they're bringing in?
Look, from a purely risk management perspective, sure, a business owner naturally wants all the data they can get. But human rights law fundamentally prioritizes the rehabilitation and privacy of the individual over the curiosity of the employer.
Interesting.
Yeah, you have to look at the mechanics of what a vulnerable sector check actually uncovers. It doesn't just list convictions. It acts as this massive dragnet that pulls up highly sensitive non-convictions.
Give me an example of a non-conviction that would, ruin someone's chances.
Okay, imagine someone suffered a severe mental health crisis 5 years ago. Police were called to their home, and they were safely apprehended and taken to a hospital under the Mental Health Act.
So no crime was committed?
None. No charges were ever laid. But that interaction exists in a police database. A vulnerable sector check can flag that incident. It also reveals findings of not criminally responsible due to mental disorder and pardoned sexual offenses.
Oh, wow. So an applicant could be rejected because a manager sees a past mental health hospital visit and just quietly decides the person is a liability.
Exactly. And that is the exact mechanism of discrimination the law is trying to prevent. If the job doesn't involve being in a position of trust over children or vulnerable adults, demanding that level of invasive disclosure is illegal.
So what can employers actually ask for?
They're restricted to standard criminal record checks. Those only pull up actual convictions and outstanding charges, completely shielding all those sensitive non-convictions from view.
Okay, but let's say the employer does the legal standard background check and an actual criminal record pops up. How much protection does the applicant actually have? Because our sources show this is where the jurisdictional split gets incredibly messy.
Oh, it becomes an absolute minefield.
Yeah.
In Ontario, the provincial code offers very narrow protection. You're only protected from discrimination if you have a provincial offense, like a serious speeding ticket, or if you have a federal offense that has been officially pardoned by the Parole Board of Canada.
Wait, what if you were charged with something but the trial hasn't happened yet?
You're out of luck. The provincial statute strictly demands an actual conviction to trigger protection. If you merely have outstanding charges or a perceived criminal record, the tribunal will just dismiss your human rights claim.
And what if the conviction is an unpardoned federal offense? Say, drug possession from a few years ago that hasn't been pardoned yet.
Under the strict record of offenses ground, unpardoned federal convictions offer zero protection in Ontario. An employer can legally pull your job offer the moment they see it.
Wow. And federally?
Federally, the laws are even harsher. The Federal Human Rights Act offers no protection whatsoever for provincial offenses and only protects federal offenses if a pardon is already in hand.
Okay, here's where it gets really interesting. We just established that an unpardoned federal charge gives you zero legal shield. But Tony Wong's article outlines this brilliant legal pivot.
Yes, the pivot to disability.
Right. How on earth does an unpardoned federal drug charge legally transform into a medical disability claim?
It relies on something called the drug conviction nexus. Let's walk through the mechanics. An applicant's background check reveals an unpardoned drug possession conviction. The employer panics and revokes the job offer.
Which we know they can legally do under the criminal record ground?
Exactly. The applicant's lawyer knows they can't sue based on the criminal record because it's unpardoned. So they shift strategies. They file a claim under the ground of disability.
But having a drug charge on a piece of paper isn't a medical disability.
True. But the lawyer's argument is that the employer didn't reject the applicant because of the paperwork. They argue the employer rejected the applicant based on the stereotype that anyone with a past drug charge must currently be an active addict.
Oh, I see. And substance dependence is a heavily protected medical disability.
Precisely.
So the entire case hinges not on what the applicant actually suffers from, but on what the employer assumed about them?
Yes. That leap in logic introduces the concept of perceived disability. In Ontario, it's explicitly written into the legislation. The code protects you against conditions that are perceived to exist.
And federally?
Federally, the word perceived was actually left out of the statute. But in a landmark case called Turner v. Canada, where a candidate was rejected because an employer perceived him as being overweight, the court stepped in.
To fix the missing word.
Yeah. They ruled that perceived disability must be treated as a fully protected ground, regardless of the missing word in the federal act.
It's fascinating how the courts force the law to adapt to human behavior, and this ties directly into what the sources consider the most important precedent in this entire space, the Supreme Court's Mercier decision.
Oh, absolutely. The Mercier case fundamentally changed the philosophy of Canadian human rights. The Supreme Court ruled that a disability is not just a biomedical fact. It's not something you can simply prove with an X-ray or a blood test.
So what is it?
Disability, in the eyes of the law, is a social construct.
A social construct. Break down what that actually means for a hiring manager.
It means the law is designed to stop social handicapping. The real barrier for the applicant isn't their physical health. The barrier is the manager acting on stigmas or stereotyped assumptions.
Like making assumptions about someone's future health?
Right. Consider a candidate who had cancer 5 years ago but is now in complete remission. If a manager refuses to hire them because they're secretly terrified the candidate will relapse and take expensive medical leave, that manager is socially handicapping the applicant based on a perceived disability.
And malicious intent doesn't even factor into this, does it?
Not in the slightest. The courts view discrimination through the lens of an objective bystander. A manager might genuinely believe they're protecting the company's bottom line, or even think they're protecting a fragile employee from a high-stress role.
But the motive doesn't save them.
It does not matter. If a false assumption about a person's health drives the adverse treatment, it is discrimination.
So, to build a case, an employee has to prove 3 things to establish a prima facie claim, right?
Yes, 3 things. 1, they were perceived to have a disability. 2, they face adverse treatment like getting fired or losing an offer. And 3, the perceived disability was a factor in that decision.
Okay, so let's unpack this defense strategy. Because if the employee proves those 3 things, the evidentiary burden violently shifts onto the employer. The company is suddenly in the hot seat.
Completely. They have to prove a negative. They have to legally justify why excluding this person was absolutely necessary.
The duty to accommodate sounds to me like a 2-stage lock on a heavy door. Finding the right key is the first step, and physically possessing the strength to turn it is the second. Walk us through how a company actually survives this flipped burden.
Well, the Supreme Court created the Myron test to evaluate these occupational requirements, which we call a BFOR, or bona fide occupational requirement.
Yeah, it has 3 hurdles, right?
Yes. First, the standard must be rationally connected to actual job performance. Second, it must be adopted in good faith. And third, the employer must prove they cannot accommodate the individual without suffering undue hardship.
Let's apply that to a real-world scenario so we understand the mechanism.
Okay, the Myron case itself involved a female forest firefighter. The government instituted this mandatory aerobic running test. She failed the running test and was fired, despite having performed her job safely for years.
So she challenged the running test itself.
Exactly. Supreme Court looked at the test and asked, does running this specific distance in this specific time actually mimic the reality of fighting a forest fire?
And I'm guessing the answer was no.
The answer was no. The standard failed the rational connection hurdle because it unnecessarily excluded women who were otherwise perfectly capable of doing the actual work.
That makes perfect sense. The test didn't measure the job, it just measured the test. Now, what about the duty to accommodate? How does that work in practice?
Ontario law splits the employer's duty into 2 distinct phases, which matches your lock analogy perfectly. First is the procedural duty. This is the investigation phase.
Finding the key.
Right. The employer is legally required to conduct a thorough, individualized inquiry into how they might accommodate the person. If an employee hands in a doctor's note and the employer fires them on the spot without even having a conversation about modified duties, that failure to investigate is a standalone breach of human rights law.
You lose the lawsuit just because you didn't ask the question. You never even put the key in the lock.
Precisely. Which leads to the substantive duty actually turning the key. The employer must implement the accommodation up to the point of undue hardship.
Now, undue hardship is a phrase thrown around in every corporate HR meeting. I imagine a lot of managers think, well, redesigning this workflow is going to destroy my team's morale and be incredibly annoying, so that's a hardship.
Oh, tribunals do not care about annoyance. In Ontario, undue hardship is strictly limited to 3 things: substantial financial cost, lack of outside funding, and genuine health and safety risks.
So if it creates a scheduling nightmare for management,
Completely irrelevant.
what if customers prefer dealing with someone else?
That is a legally prohibited factor. You can't use customer preference. And to prove substantial financial cost, a business owner can't just say an accommodation is expensive.
What do they have to do?
They essentially have to open their financial books in court and prove that buying, say, a $5,000 piece of ergonomic equipment will literally threaten the financial viability of a multi-million-dollar company.
Which is almost impossible for a large corporation to prove.
Exactly.
But, this rigid, uncompromising standard was hammered out in the 90s and early 2000s, and now it's colliding head-on with modern technology. We are looking at massive new liability risks.
Let's talk about AI in hiring.
Oh, this is a huge minefield.
Right. If a company uses an AI resume parser that just objectively crunches data and looks for employment gaps, how can that algorithm be guilty of discrimination? It's just code. It doesn't even know what a medical condition is.
Tech companies love to use that defense, claiming the algorithm is neutral. But the law looks at the effect of the tool, not just its programming. This is called proxy discrimination. Proxy discrimination. Explain that.
Well, a resume parser is programmed to flag large gaps in employment because it equates gaps with a lack of ambition or outdated skills. But why do humans typically have large gaps in their resumes?
Usually because of a major life event, a severe illness, a stint in rehab, maternity leave.
Exactly those reasons. So when the AI automatically trashes a resume because of an 8-month gap, it is indirectly penalizing someone for taking medical leave to treat a protected disability.
The AI is executing social handicapping at scale.
It really is.
And what about algorithms that scrape the internet for background info, open source intelligence?
That is even more dangerous. An AI tool scanning social media or court databases might uncover withdrawn charges or pardoned offenses that an employer is legally forbidden from considering.
Oh, I see.
If the algorithm lowers a candidate's viability score based on that scraped data, the employer has violated human rights law, even if a human hiring manager never actually saw the withdrawn charge.
Wow. Ignorance isn't an excuse. Since we are talking about modern traps and assumptions, there is also this blurring line between what you do at the office and what you do on your own time. The sources outline the stunt driving paradigm. How does a weekend mistake impact this legal framework?
Well, consider an employee who works a standard desk job in marketing. Over the weekend, they get charged with stunt driving, which is a provincial offense.
And provincial offenses are protected in Ontario.
Right. So under the provincial code, the employer cannot legally fire that marketing employee merely because they acquired that specific record.
But what if the employee isn't a marketing manager? What if they're a commercial truck driver who gets the exact same weekend stunt driving charge?
The context changes the legal outcome entirely. If the truck driver gets the stunt driving charge and their driver's license is suspended, the employer can absolutely terminate them.
Wait, but it's the exact same provincial charge.
It is. But the crucial distinction is why they're being fired. They aren't firing them for the social stigma of the offense. They are firing them because the employee lost a fundamental credential required to legally operate a heavy vehicle.
The mechanism is different. Without the license, they physically cannot perform the duties of the contract.
Yes. In contract law, this is known as frustration of contract. Under human rights law, possessing a valid commercial license is a justified bona fide occupational requirement.
So it's completely legal.
Exactly.
So if a rogue algorithm screens you out or a manager fires you over a false medical assumption, how does an employee actually fight back without getting buried in the wrong paperwork? The sources lay out 3 different legal avenues, and it feels a lot like picking a character class in a video game.
That's a great way to think about it. Every path has different stats, different limitations, and different ultimate rewards. You have to choose your battlefield very carefully based on what you actually want to achieve.
Okay, so what is the first path?
The first path is going directly to the human rights tribunals.
What's the strategic advantage there?
Tribunals have incredible power to enforce non-monetary remedies.
Right.
If you want a judge to force the company to reinstate you to your old job or mandate human rights training for the entire executive board, this is your venue. You can also win general damages for the injury to your dignity.
But there's a catch, right?
A big one. The limitation period is brutal. You generally only have 12 months from the date of the incident to file your claim.
That's a really tight window. What if you were officially fired and you just want maximum financial compensation?
Then you take the second path, civil litigation. You sue your former employer in the superior court for wrongful or constructive dismissal. The powerful tool here is Section 46.1 of the Ontario Human Rights Code.
What does that section do?
It allows civil judges to award human rights damages right alongside common law severance pay.
So you stack the damages together to build one massive, high-value lawsuit.
Correct. It consolidates your leverage completely.
But then there's the third path, the intersection with workers' compensation, or WSI. And reading through the sources, this one feels like a massive strategic trap.
It absolutely can be.
Because if workplace harassment over a perceived disability causes an employee to develop a diagnosed traumatic mental stress injury, they can claim WSI. That sounds like a good thing, right? They get compensated for the psychological injury. Why is it a trap?
It comes down to the historic compromise of the workers' compensation system. A century ago, workers gave up their right to sue their employers for injuries in exchange for a guaranteed no-fault insurance payout.
Right.
But when the injury is a mental health crisis caused by human rights harassment, those two legal doctrines collide. If an employee elects to enter the WSI system to get those immediate wage loss benefits, they may become statutorily barred from suing their employer in civil court for constructive dismissal.
Oh, wow. So they are trading a potentially massive severance payout in civil court for a much smaller but guaranteed workers' comp stream. And they can't have both.
No, you cannot double dip. It requires an incredibly strategic election of remedies early on, and once you choose a path, reversing it is incredibly difficult.
It really is a game of chess, not checkers. As we wrap up this deep dive, the overarching lesson for you, the listener, is clear. Canadian human rights law is not about operating on a general sense of morality. It is a highly technical, rigid arena.
It really is.
Whether you are an applicant getting your resume parsed by software or a business owner trying to manage a complex workforce, you have to understand the specific legal doctrines and apply them in the correct venue.
The mechanisms we've discussed rely heavily on human assumptions, but that actually raises an entirely new dilemma for the future.
Which is?
Well, as we move into an era where AI algorithms conduct entire interviews, analyzing micro-expressions or vocal tones, we have to ask, who is legally responsible when a machine perceives a disability that a human never would have noticed?
Oh, that's wow.
Right, when the social handicapping is being done by a string of code reading your facial tics, how will our courts define intent?
That is an incredible thought to end on, because eventually the boundaries that define these legal tests are going to become just as blurred as the lines between human intent and algorithmic bias, and we are all going to have to navigate that murky legal landscape together. Thank you for taking this deep dive with us today. Keep questioning the systems around you, and we'll see you next time.